No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good afternoon, Houston. Welcome to another Ask the Expert show where we bring you the top experts in the field of legal, health, financial, and home improvement. 12 years ago, when we started Ask the Experts, we had a community association firm start with us in Florida. And I learned so much about associations. It was amazing. All the information there is to know. If you're a board member, this is just the perfect show to watch or to listen to. And I've wanted for the last 4 years to have a community association law firm, but we've been basically had no room. We finally got a space, and we were so lucky we found the top community association law firm in the Houston area, Lang and Associates. Let me welcome you to Shannon Lang. Good afternoon, Shannon.
Hi, Steve. It's so good to be with you again.
I got to tell you something, Shannon. I am so proud of you. You just, from the first show on, you stepped in and you make the information so easy to learn. And oh my God, Shannon, I have learned so much about community associations, and I can't even imagine an association not having a firm, especially a firm like Lang and Associates, to assist them. There's so many things to know about, isn't there?
There really is, and thank you for that. I really appreciate that. We really like being, focused and having a specialty, and really being able to dig into all the intricacies of association law. I wouldn't say it's as hard as antitrust or as complicated as securities, but it affects so many people in our community. Particularly here in Texas, so many people live in homeowners associations and condos, and we really enjoy having that connection with people whose lives are really impacted by what we do in a very, very real way.
I got to tell you, we get more letters thanking us for bringing your show. In fact, it is our number 2 show of all of our Houston shows, which is amazing, because some of them have been with us for 10 and 11 years. People are learning so much from your show, and it's just, I'm so glad we have you. Tell people, first of all, about Lang and Associates.
Sure. We are a small women-owned law firm here in Houston. I started this firm in 2015 after spending many years in big law, big international law firms, working for big corporate clients. We have slowly, organically grown our community association practice. It now takes up about 80% of our time, and the rest of it is devoted to general commercial litigation, which for us is really important because it means that we're in court, we're litigating, we're in front of judges, we're arguing to juries regularly. And while there aren't as many jury trials and court appearances with a lot of the HOA work, when you do need someone who's going to go into court, you want someone who's comfortable in court. And I find that a lot of our competitors are great debt collectors, but court scares them. And for us, we want to keep those skills sharp. We're in court a lot. I was in court this morning. I was in court yesterday. And we think that's what we really bring to the table, coupled with a real focus on customer service. We don't have phone trees. We don't have a series of people sitting in cubicles, burning through their job and quitting. We have a stable staff that answers the phone, and everyone who answers the phone knows that their goal is to solve the problem of our homeowners and board members who are on the other end of that line. And we take a lot of pride in making sure that that's what we do every single day.
Well, we actually got a letter from one of your clients that had another firm representing him, and she said what she loves about your firm is you always get back with everybody right away. The firm that they had, sometimes it would take a week for them to get back with them, and you just can't do it in the business you're in.
Yeah, it's challenging. I mean, we get hundreds of emails and dozens of phone calls a day, but we try really hard to be responsive. And when there's a period of time when I can't be, we're in trial or we have something going on, we always try to communicate that so that people have good expectations about when they'll hear from us and when we'll follow up. But our goal is to answer the phone the first time it rings. And I think that we do that 99% of the time.
Well, let's get to God. We've got a lot of questions from listeners. The first one is about townhouses. They want to know apparently they live in a townhouse. What rules apply to a townhouse?
Sure. I mean, we get these questions a lot. In fact, I was just sending an email about it before we started the show. The important thing to know about townhouses is that they're not really an association entity. They're an architectural style. And some of those townhouses are set up as subdivisions and some are set up as condominiums. And those are the two distinctions that determine what set of rules apply to your association. Are you a subdivision where common areas, if any, are owned by the association, where you own from the foundation to the roof and the land that you're sitting on? Or are you a condo where you have an undivided ownership interest in all the common elements along with everybody else, and you only own really from the drywall in of your unit while the association owns everything else? And the rules are very different for those two structures of ownership. And I will say that the one thing that comes to play a lot when this question comes up is for people in condos, they're paying much heavier assessments than people in subdivisions. And that's what I think drives a lot of the questions and a lot of the concerns. But the difference, of course, is that with a condo, your assessments are paying for a lot of things that an individual owner in a subdivision pays for themselves. Your insurance, fire and loss insurance, all the maintenance on the exterior of your units, common elements. Most condos have a pool or a gate or private driveways. Some have tennis courts. And so your assessments pay for a lot more than for a single family home. But in more direct answer to the question, what you need to do is look at your declaration, look at your deed, and it will tell you whether you're in a townhouse subdivision or a townhouse condominium.
This is from Marvin. He wants to know, we do not have enough handicap parking. What can I do to try to get more handicap parking in our community?
That's a really
He
good
didn't
question.
say if it was a condo or, yeah.
Yeah, I'm going to assume it's a condo since most subdivisions are on just public roads or generally accessible roads, but the rules are really similar. And this is a good question because we've gotten a lot of this lately. What do we do for our disabled residents? And the question really is, what kind of accommodations do you need to offer to a disabled resident under either the Americans with Disabilities Act or the Fair Housing Act? And most of the time it's the Fair Housing Act that applies, although they're really a distinction without a difference. The idea here is that all residents in a community are entitled to equal access to their home and basically the ability to live just like everybody else. So if you're in a community with a number of disabled residents who have mobility restrictions and need parking accommodations, you don't necessarily need to block off more handicapped spots per se, but for any individual who needs a spot, you can and should assign it. You can't ask for medical records, but you can ask for reasonable documentation of a mobility impairment if it isn't obvious, and then provide a reasonable accommodation. For some communities, that involves assigning a parking space that's close to a unit. In others, it might be simply providing more handicap designated parking. It really depends, but this should be something that is raised with the board. And I would say that if your board is not being very responsive, that I would recommend kind of using some of this legal language, like, under the Fair Housing Act, I really think we need to do this. And, for Marvin, if he is a disabled resident who himself needs accommodations, then I would recommend a letter to the board or the management company stating that, I live at such and such unit, I have a mobility impairment, and I'm not able to park in a way that enables me to adequately access my home. I request assigned parking. And you should get a response fairly quickly. You might not get exactly what you asked for, but the association is obligated to engage in a discussion to determine reasonable accommodations. They must at least have some back and forth and try to reach something that everyone deems reasonable. In most circumstances, assigned parking shouldn't be that difficult to provide, but it's very fact specific and it really depends on the community. So I would say start with your board, explain the situation, and make sure they understand that legal exposure for disability-related claims can be substantial and litigating them can be very expensive, which we know because I'm starting to think there must be some blog out there that tells everybody if you live in an HOA and you don't like the rules, say you've got a disability, they have to let you break them. It's not really accurate, but we are getting a lot of disability claims lately. A lot of claims.
What else you're going to start getting for condo, because we're getting them here for your show, is people wanting more of these electric vehicle charging stations. How do they go about getting more stations?
Yeah, I mean, this is challenging because of expense. We get a lot of requests from owners and board members saying we want to do this, that, or the other, but condos don't and subdivisions don't mint money. And so you always have to find a way to pay for this. This is obviously, again, a bigger issue in most condos because most homeowners should be able to put charging stations into their home in a subdivision, but not always. Check your declaration. But it's a question of capital improvements. Right now in Texas, there's no requirements for a certain number of charging stations. There's no requirements that there really be any at all. While this possibly could fall under an FHA claim, depending on the nature of the disability, just note in that case, it might be the case that the owner has to pay for it themselves, but the challenge is always in funding. And so I would say if this is a big issue for your community, that go to the board or get on the board and see if you have owner support for this. If you've got a healthy funding, adequate assessments at a reasonable rate, and I will say most of our condos don't charge enough, there should be plans at most years for some type of maintenance, repair, or improvement, and a project can be placed underway. There's also often the option for big capital improvements to seek bank loans, but those can be complicated. Lenders want to see a really healthy bank account. They want to see that your delinquency rate is very low, and they're often going to ask that there's a special assessment or an assessment increase included in connection with the loan to provide assurances that it can be paid off later. But loans are a way forward as well. But ultimately, whether to put these in is a board decision, and the board is, should be responsive to the owner. So if you have a big push in the community for this and people are willing to fund it, hopefully your board listens.
Gail in Memorial wants to know, can the board make me sell my condo at the price they request?
Oh, well, that goes back to, as so many things do, your declaration. A lot of condos do have rights of first refusal. And so you need to look at the language and see what it says. Now, what it should say is that it's a right of first refusal at a fair market price or similar to a price you've received on the market. But if there is a right of first refusal, the condo can exercise that right. There are, of course, exceptions. If they haven't exercised it in many years and they're only doing it for you, you might be able to argue waiver. But as a general rule, if that's in your documents, read them carefully and make sure they're following them. Can they force you to sell? Of course not. But can they force you to sell to them if you are selling? Maybe. But you should still be getting a fair price that's reflective of the price you would get on an open market.
Here's a boy, we're getting a lot of text already. Here's a this is Marla in Memorial also. She's a board member. She wants to know, she said, first of all, I am really enjoying your show. I just found it. I am going to have our board members start listening to your show.
Perfect.
I want to know if you had a wish with Texas laws when it comes to associations, what would be your number one wish if they had to change and better a law? Does that make
I mean,
sense?
yeah, it does. I mean, there's so many things we'd like to change. I'll give you a few. Two legislative sessions ago, this really weird law was passed about front yard fences. It's created a lot of issues for our communities. As you can imagine, many communities have these open vistas and setbacks, and they don't want big fences around the front of the house. There have been some efforts to change it. It hasn't quite gone the way I would hope, which is just a flat rescission. My feeling is if you move into a community that says no front yard fences, you've made that choice. And, to suddenly have a neighbor throw one up can be challenging. I would also like to see a little more clarity around what the management companies can charge for delinquencies. The management company industry is challenging. There aren't a lot of barriers to entry. There are a lot of companies in these major metropolitan areas. And I think as a result, it's really created price competition where the management companies have to make their money through volume. So they drive down their pricing to get clients, but have to find other ways to make it up. And one place where we see that is in a wealth of questionable fees assessed to delinquent owners for monitoring or administrative tasks, which I struggle with, because once an account comes to us for collections, we need to be comfortable standing in front of a judge and saying these are legitimate charges that should be awarded to the association. And while the association is entitled to recover costs of collection, it's a really squishy term. And sometimes I think some of these aren't really costs because they're not really doing anything to collect. So I'd like to see some thought around what cost of collection means. Importantly, though, in a way that maintains the industry, because it is an important industry, the management and the legal side of it. HOAs are kind of mini little political entities. And if you aren't in an HOA, you're being governed by your faraway elected officials who tend to be way less responsive than your neighbors. So, I'd hate to see anything undermine the value of a homeowners association. But I do think that there are a few abuses out there that we would like to see clarified or addressed by our legislatures.
What about support animals? Do you get a lot of questions about that?
We do. It goes back to that ADA, FHA issue. Service animals, like legitimate service animals, should, as a general rule, be permitted, even in communities with restrictions. Typically, if someone has a legitimate service animal, they have a true disability that justifies it. If you have questions, ask your lawyers before you ask the resident, because again, if you ask too many probing questions, you can start to run into some problems. But the emotional support animals raise some different issues, and they aren't considered service animals under the FHA or the ADA, but that doesn't mean that you can preclude them altogether. These disability-related claims are very fact-specific, and we always suggest that you engage in that discussion, that interactive process of determining accommodations when somebody comes and says, I have an animal that's disallowed under the deed restrictions, but here's why I need them. You should have that conversation. You should almost always do it in consultation with lawyers, and always be thinking in terms of reasonableness. It may often be reasonable for somebody to have a 20-pound beagle. It may often be unreasonable for them to have 4 80-pound pit bulls. And the boards and the associations are entitled to a reasonableness inquiry when faced with questions about how to accommodate somebody with a disability.
I guess it's always important because everybody's got different documents,
Mhm.
and it's really important that people know and understand their docs. What about, I just had someone wrote me, what kind of background should you have to run for a board?
The only thing you really need to run for the board is a desire to serve. While it can be helpful to have some background in construction or in real estate or in property management, it is by no means required. As a board member, you should have ready access to professionals who can help you with those things. And we find generally it is so hard to get people to volunteer for leadership that anybody with the desire is a good board member for us. The issues we find and the things I would caution you against is you're having a problem with your unit and you don't feel like it's being adequately addressed. So you're going to run for the board to get your place fixed. That can be a problem. As a board member, particularly for a condo, you've got fiduciary duties that require you to elevate the interests of the association over your personal interests. And so, we're always a little worried about folks who are on the board to serve a personal need. But, with good representation and lawyers and managers, we can generally work around that and explain why you can't just get what you want because now you're on the board. But, we do love seeing anybody with an interest in serving, anyone with a desire to make their community better. And as a real practical matter, someone who has a couple hours a month available to dedicate to their association. That should be all it takes most of the time. There will be times when it's busier, times when it's less, but with a well-run organization and good professionals around you, you shouldn't feel like this is a second job. So a desire to serve, that's what we're looking for.
Shannon, tell people how they can reach your office.
Absolutely. We're on the internet at shannonlanglaw.com. You can also just Google Shannon HOA Lawyer Houston, and I'm the only one who comes up. We can be reached on the phone at 832-479-9400. And as I mentioned earlier, we answer the phone. You'll hear from Mackenzie or Ashley. They are answering our phones every day from 9 to 6. And we welcome calls. We're happy to answer calls, even if somebody's not calling looking for new representation. We like forming those relationships, and we generally find that they come back to us if they find us helpful and available. And we are.
It's so easy doing your show. Shannon, thank you so much. And what we're doing now is we're going to be replaying the show again next week. Plus, it's also on iHeart and on Spotify. You can go back and watch all Lang and Associates show. Shannon, thank you so much. We'll see you again next month. And for those of you who want to again rewatch the show, we're going to be replaying the show next week. Thanks, Shannon.
Thanks, Steve. See you next month.
And we're going to go to a short break. We'll be right back.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.